Thanks, Renee, and welcome everybody to this week's edition of IPWatchdog Unleashed. This week we have a special conversation. This is being recorded at the end of our AI 2025 program, and I have three folks joining me here today. I have Stephanie, Clint, and John. I'll ask them to introduce themselves a little bit more, tell us a little bit more about what they do. But this is a conversation that I've been looking forward to, because one of the things that probably nobody knows yet except for these three people, and then also Wen Xie, who's unfortunately unable to join us here today, is I've reached out to these folks and asked them if they wanted to become more involved in what we do with IP Watchdog. And we kind of are forming like an ad hoc committee to advise Gene. So you've seen all of these folks at our events. You've seen them on the stage. You've seen them as panelists. You've seen them as moderators. And I think you're going to see more of them in the future. And I appreciate you all agreeing to help me brainstorm the programs, write articles, and all that sort of stuff. So I'll let you introduce yourselves, and we'll start with you, Stephanie. Tell us a little bit about what it is that you do and in the industry and what your focus is on. I know you really care about AI a lot.
Yeah, absolutely. It's become my life's work apparently. So, formerly practicing attorney, I had a patent preparation prosecution practice, primarily in life sciences, and then got very enamored by the capabilities of language-based AI systems to transform patent practice. It was sort of like a holy crap kind of moment when I first got introduced to these systems. And I haven't really looked back since. Started a company called NL Patent at a very early stage in the evolution of language-based AI systems and its applicability in the commercial setting. And because of that, was very embraced by the IP community, in particular the American Intellectual Property Law Association. I have served in a number of different leadership roles within that organization, starting as chair of the AI subcommittee, then moved up to the Emerging Technologies Committee, which I've served as vice chair for two years, and then chair for 2 years. What a time to be part of the emerging technologies and AI space, both as an attorney, as a founder of a technology company, and as somebody who's deeply involved with the evolution of the policy. I also serve as a board-appointed member of the AI task force, and of course we've seen lots of comment requests around AI and emerging technologies, and I have served the organization to both be sort of a fly on the wall in many discussions between different stakeholders, as well as contributing directly to some of the organization's position on those policies. So it's been an interesting career so far.
I bet it has, and that's when I saw all the stuff that you did. That's when we got to know each other through your work as chair of the committees that you've been on, and I'm just glad you're going to be around helping us with our AI focus and content and so forth. So thank you for being here. Next, Clint.
Man, I am really boring compared to Stephanie.
Well, you're a patent attorney. Of course you're boring.
Of course I'm true.
We're all boring. But you have written some really great articles for us over the years, and you've been coming to our events for a very long time. And I appreciate you agreeing to step up and help me put these together and do panels and that sort of thing.
Thank you. Yeah, I've always really enjoyed your events. Honestly, the most important part is just the community of people that are here. It's not as huge of a conference as some of the patent law conferences. And honestly, it's been a great way to make friends and, to really make yourself think outside the box and, analyze, what you're doing for your clients at a level, but also the bigger picture, which is really important. And honestly, it's what makes the job interesting. If you're just looking at the trees all the time, it gets a little stale. And honestly, you're not doing the best work for your clients if you take that perspective.
Well, great. Well, thanks for being here, Clint, and thanks for helping out. And last but not least is John Rogitz. And John is the person here that I've known the longest. We've known each other for almost 15 years, I think, maybe even longer. But, we met. I remember the first time I actually met you in person. I was shocked to see you. You see people virtually and on the internet and by email, and then you came out to Southern California, where I was speaking at the Orange County Bar Association, and you came up, and I wasn't expecting you to be there. I didn't recognize you, which I felt really bad about. And I'm like, oh my God, John.
Yeah, it's actually really incredible that you brought that up. I couldn't sleep the other night, and I was thinking about that in bed, and I was like, I wonder if he remembers that was the first time we met or not.
I do.
I
remember that was
recounting the story.
Yeah, that was in Newport Beach, California.
Yeah, it was. Yeah. So, look, I'm very happy to be a part of this. I'm honored and I'm humbled. I've said it before. I'll say it again. I really do consider you to be the oracle of patent law. You seem to know everything about all IP, really, and the fact that you would be asking us to contribute is really just incredible, and I'm happy to be aboard.
Well, I'm glad you're aboard. I thought you might say that I know everything about everything, and if you were going to say that, was going to call Renee into the room and ask her to repeat it. So you all on listening to this at the podcast may have just heard we are in front of a live studio audience recording this. This is the last segment of our AI program. We can talk a little bit about AI if you want. Talk about whatever it is that interests us here. But the one thing I did want to talk about, at least to some extent, AI, and we can, wherever it takes us, it takes us. You've all been here for the entire program. Well, you were a little late because you had some plane issues, Stephanie, but you got here and you've been here for a day and a half. And I know you two have been here for all 48 hours of our program. Was there anything that you heard or that surprised you, or something you heard that you didn't expect, or something you heard? Well, maybe we can get to the stuff you disagreed with later on. But if there's something you heard that was like, wow, I didn't realize that. John, I saw you shake your head first, so you get to go first.
So yeah, it was a really strange change in tone from Jason Allen Snyder, like the AI expert, the technical, non-legal person who led off the first panel. Because I've spoken with Jason at length before about AI and its implications for society and things like that. And he was always the one to sort of pump the brakes and be like, don't worry, it's not taking our jobs, the world's not ending, everything is okay. I remember speaking to him about that New York Times article about ChatGPT, the famous one, right when ChatGPT came out and it was like Skynet's going live, right? And I brought that up to Jason. He's like, whoa, slow down, everything's fine. But then he got up here this time and he starts throwing around terms like existential threats in reference to AI. Mm-hmm. And I went, well, that's a huge change in tone for Jason. The fact that now the person who knows on a technical level what's happening, is starting to say things like that, gave me a lot of pause.
Yeah, it does. Because he's been a good friend of mine for a long time. Yeah. And it just so happened when we started doing these AI programs that I knew him. He's one of the top 30 thought leaders on artificial intelligence in the world. So when he says something, you got to start to scratch your head and say, huh. Yeah. And last year when he was here, he scared the hell out of me last year when he said, was answering the question, giving his preliminary thoughts, and at the end, just as almost like a throwaway, he said, don't worry, the machines aren't going to kill us yet. And I'm like, okay, well, let me dive into that yet part. How about we say like never? The machines are never going to kill us. And he said, well, we can't say that. There's a lot of choices that we need to make as we're making these tools, and a lot of guardrails that need to be placed. And if we get it wrong, then Terminator might become a documentary. My words, not his words, but I do sense that the people who are working on the front lines of the really exciting stuff are almost like they're looking over into the abyss and seeing what maybe it could be, and are getting a little worried. And I don't think we have to worry about Jason. Thank God people like him are not Dr. Evil. I told him that after he talked. I'm like, I'm glad you're on our side, and like humanity's side, because some of these people could be Dr. Evil kind of smart. They are Dr. Evil smart, and they could do a lot of damage. And I think then there's a whole other group of people that aren't given enough consideration to the ramifications of what they're doing. Not that they're trying to release Skynet, but who knows where this is going to go.
Yeah, 100%.
Yeah. So, Clint, was there anything that you heard that shocked you or surprised you? Or?
Yeah, I think that the consciousness of AI in 13 to 15 years, the prediction that was discussed on the first panel is one of the most interesting aspects of it, because when ChatGPT came out at first, it was, oh, this is amazing, this is going to change everything, and then like a couple months later, it's like, oh, this isn't going to do anything. It's not going to take. I feel like everybody gets a little defensive, like, well, it'll take everybody else's jobs, but it's not going to take my job,
Right,
because
right.
Even I wrote that article for IP Watchdog, a year ago, that it's like it'll draft the specification, but it's never going to draft claims,
Well, the one thing that we do have going for us, which is both nice and awful, is on the claims front, the Federal Circuit can't even agree, right? So until you get an AI that can read minds and accurately predict what the Federal Circuit is going to do, and good luck with that. I mean, because like just recently they said for your Jepson claims, you have to have support in the specification for all of the prior art.
crazy.
Did you see that coming?
No.
I mean, that's like silly talk. I mean, that's just stupid talk. Hopefully that gets taken care of en banc or panel rehearing or something. Because I think that they can get the same answer to that case, the same result that they wanted, without saying something that's just like, oh, no, you didn't.
Yeah. I mean, if AI can, give us advice on patent eligibility, that'd be fantastic. Like, when does a claim switch from being at a high level of generality to a non-high level of generality?
Right. Well, that was the one thing that caught my attention really specifically, and maybe Stephanie, you can comment on this as well, since you're sort of the AI expert on the panel, all things AI. But I was a little surprised to hear in the quantum panel. Because those folks do regular garden variety software, and now they're doing quantum, some of them hardware, some of it software, and they seemed to be saying, well, the message I got, at least the takeaway that I got, is on the quantum side of things, there is not a 101 problem. There's no patent eligibility problem. And they didn't have a really good explanation as to why that's the case, because at least the way that these things work and the way you're describing them on the quantum side is really very similar, if not identical, to the at least format and structure, the way you're describing things on the classical software side. And it just, so what it feels like, and what it brings us up when Clint says, if you can, the AI can predict this. I mean, the only thing that gives me any hope of predicting that is quantum difficult. Classical software, not difficult, to put it in Neanderthal terms, But that does seem to influence an awful lot.
I think what I took away from that panel at least is just the level of complexity. I know that, very few people really understand quantum to begin with. And then when you have experts that are so deep in that space and so intimately familiar with the technology, it's sort of almost, throwaway. Of course not, there's no 101 issue. Why? Well, it's obvious that there's no 101 issue, and there's like a disconnect between explaining why and just inherently knowing why. And I feel like that's sort of a common thread amongst any discussion around quantum. It's like, well, it just is what it is. It just is that way. And so that's something that we've talked about pretty extensively in my committee as well. And trying to unpack this, the quantum world that seems to be definitely the future, but very difficult to grasp. And the related patenting issues that may arise from it are a little bit uncertain right now, at least from my perspective.
Yeah, and I don't think that I think the panel that we had was they were very honest, right? And I don't think that they were just saying, there's not, like, they weren't doing the Obi-Wan Kenobi. These are not the droids you were looking for. They were just being descriptive. And I don't think they have a good answer as to why are examiners treating it so differently. Just they were descriptively telling us that they do. John, I mean, I know you do a lot of software, and you've done a lot of work in particularly with video games as well, which is all really software and optics.
Yep. Yeah, and games. I mean, which are supposed to be not patented, but everything. The modern video games are so technically complex that it never boils down to just rules for a game anymore. With quantum, I think it's probably still so new, and as the panelists yesterday said, everyone's sort of figuring it out on the fly, including examiners. So they're figuring out how to issue rejections on the fly. And I hope none of them are listening to what I'm about to say, but it just strikes me that quantum in particular would be right for 101 challenges on natural laws of nature. I mean, you're using quantum, but you're using it in a highly technical way. So maybe that's the other side of the coin there. But I don't think that they'll be immune from 101 challenges. That it's going to come. I think people are just, they're trying to figure it out and they don't understand it, and they're going, oh, well, I don't understand it. It's got to be really sophisticated and technical, and therefore,
I think
eligible.
you're right. I think there's a little bit of that going on. Is and it's not to throw shade at the examiners. We had I had a little fun with all of you in the audience here during that panel, and made fun of you for a minute before I admitted, well, I don't get it either. I mean, quantum is one of those things that I don't even know that the quote unquote the experts really understand. They can describe what's happening, but does anybody really understand? I mean, and I was talking about the Einsteinian, this particle can exist in two different states at the same time, in two different places at the same time, and it's like, I can't wrap my brain around that. But if you can't wrap your brain around that, I'm not sure you have any real hope to unlock what the quantum computer is doing.
Yeah.
And so I do think that there's a little bit of a black box there where, and maybe I almost think that this would be a smarter way for examiners to look at a lot of different types of innovation, is step back and look. And if something unexpected is happening, is the result, then there's got to be something going on there. I know when I was practicing and working on innovations, people would come to me, and a lot of times I work with first-time inventors or small company startups, and they don't always have the ability to explain to you why it's doing what it's doing. Sometimes they may not even know why it's doing it, but they stumbled onto something, and they know the result is dramatically better than what has happened. And I always then took this position that, well, okay, then there's got to be something, there's got to be a there. We just have to try and figure that out. Mm-hmm. And I think that's what's going on the quantum side at the office that does not go on the side of classic software, because we do live in this world where, like, Clint, I think you said to some extent, it's not going to affect my job, right? Yeah. There's this group think, right, that, well, oh, it's just software, that's easy, anybody could do it. And 99% of the people who think that couldn't write any code. So when you're going through the office, Clint, I know you've written a lot for us on prosecution strategy specifically. Mm-hmm. What's the right approach in these high-tech areas where we as patent attorneys and even the inventors struggle to tell us what is going on?
Yeah, I think, as John alluded to in our last panel, like, interviews are the best first basic step to, educating the examiner on the technology, breaking things down. And I've actually found that it's, pretty powerful over the years to, just to simply tell the examiner, our client's actually doing this. This is the reason that they're patenting this. This is something that's valuable for them and it's going to be important. And they've, felt that it was important enough to file a patent application for it. And then you break it down, the differences from the prior art in a very simplistic manner. And a lot of the time, it's because you frankly have a new examiner that really doesn't understand the process of patent examination, and it doesn't want to grant a patent where they're wrong about it. They don't understand it, so if you don't understand it, you're uncertain about it, and uncertainty leads to rejection. So the best, and this popped up a few months ago with an examiner. There was multiple office actions issued, and I took over the prosecution and immediately got the brand new examiner and her supervisor on the phone and essentially ask a bunch of questions in the interview agenda to understand her perspective of what the technology was. And once I actually sat down and listened to her perspective, it was very easy to be like, no, that's not what we're doing, this is what we're doing. And I think that's key, is learning the examiner's position, and because if you don't, then you go arguing the wrong thing and explaining the wrong part of it, and it doesn't get you anywhere.
And puts estoppel on the record.
Yeah. So what is your position on demonstrations? And I see the people who are listening to this aren't going to see the roll of the eyes you just gave me, and I know it's loaded. And the reason I bring that up is because, like my friend John White, I taught the PLI Patent Bar Review course I've been doing it for 26 years. He's been doing it for longer. And he always says, if you are tempted to bring in a model or an example to the examiner, he says you need to lie down until that urge passes, because you just don't want to do it. And then, like everything John's ever said, when you get to that, like yogi level, that, Obi-Wan Kenobi level that he's on, there'll be times when you violate those rules. And he's got a couple stories about when he's violated that rule, and it always works out extremely well. One of them is with shadowless lighting. An inventor of his invented shadowless lighting, and the examiner's like, okay, well that's like fusion or fission or whatever. It can't happen. That's like that's the unicorn. And so he brought the system and set it all up and turned it on, and then the examiner waves his hand in front of a piece of paper, and there's no shadow. And he waves, and then the examiner starts like going like this, and then he sits down and he says, okay, explain that to me. But having seen it, nobody would have ever believed it, right? Yeah. And it was a bunch of little lights and from different angles and set up that there was, it probably was a shadow there, but it was not perceptible shadow, so for photography, it was perfect, right? So I think of that example and some of the others I've heard John tell, and then in this space where, you just say, I'll tell them that we actually are doing this. Because I think that does matter to examiners. This is not just theoretical. But what say you about demonstrating?
So I actually have a really interesting story. I told you this at the last conference. So it was a pretty simple invention and a small inventor. And I thought I still think it's a very cool invention. The inventor was very passionate about it. Set up a Teams interview, with myself, the examiner, and the inventor, and get into the interview. And there was some allowable subject matter. I had proposed amendments in the agenda and had a small typo in one of the amendments. And the examiner starts to hammer me about, you have allowable subject matter already. Why are you proposing these? And I responded, I'm just trying to, look out for my client, the best interests of my client. And he's like, and I'm trying to look out for the best interests of my client, the United States of America. So I was, very taken aback by this. And I'm like, all right, like younger me would have been like, screw this examiner. Like,
right.
I'm going to argue with him. I kind of sat back and just let him quiz me, tried to provide answers. And then the inventor, he actually pointed to the inventor. He's like, what do you have to say about this? And he had the product and he showed it, and he was like, okay, that's cool. And then talked to him a little bit. And then in the examiner interview agenda, sent forth a proposed amendment that was allowable subject matter, which was, crazy. So that's a good instance of, the examiner might seem combative or, have, a certain position on it. But if you can have, something that really shows the importance to the applicant and how the improvement, then it really does help.
Yeah. And the thing that goes through my mind too now is like, if you get an examiner like that, it's like, look, we got to get all the claims we can get here, because maybe you've noticed the Federal Circuit doesn't seem to like continuations anymore.
Yeah.
And they're saying that prosecution laches, and in years past, maybe we would have been willing to move that claim out and file a continuation, and it's like we just can't do that anymore, at least not right now. But because I think when examiners do understand what it is you're doing and why you're doing it, then it's a different approach. It's you're not talking past them, you're talking to them.
Exactly. Yeah, that's a big problem a lot of times with prosecution. If you're just arguing, in writing, it's kind of like texting somebody and getting into an argument with them and, having a misunderstanding, continuing to text them. It's like, that's not how it's going to work. Pick up the phone, you'll resolve it in a couple minutes. Right.
Unless you're married, then you got to keep texting, so God forbid you don't say what. I should probably just shut up. So Stephanie, was there anything that came up that was that really particularly caught your interest, or maybe that you disagreed with over the last couple days?
So there was something, and I leaned over to Clint and I mentioned something, and I can't remember what that was now. Do you remember?
I don't.
There was something pretty surprising that I was taken aback, and I thought, oh, I really didn't know that. Of course, it'll be lost in sort of history. But something else that I was thinking when we were having this discussion a few moments ago is just around consent of data and how that might play out in the coming years, and just how much data is being used to train models without any consent. I was just speaking with somebody this morning out in the audience about a podcast I was listening to this morning. Surprisingly, that
was IPWatchdog you were listening to?
No, it was a podcast called 99% Invisible. I like that one a lot. It unearths some very surprising foundations of how modern society is constructed. And one of the things that they were talking about is the use of data for training AI models, in particular, the use of Enron emails to train AI models to recognize sort of language and sentiment in written communication between these executives. That was all part of discovery, of course. It was all made public. I don't know if you've ever heard this, but I thought that was quite fascinating. And when you have, of course, that raises questions of bias and other things like that. So it's very important to train on a very broad spectrum of data. So we had a panel about that topic. And when you get into that territory, requesting or even backtracking and trying to, after the fact, try to request some consent to use data after it's already been sort of out, the train has left the station kind of thing, is something that would be unwielding to do as an afterthought. Forget about licensing actual publications, but how about everything else on the internet?
Yeah. Yeah, I'm still thinking, why would anybody use Enron emails? But I suppose if you're trying to train the AI to identify, how do you identify, so that we know that there's a collapse, the biggest collapse in the history of corporate America is weeks away. Can you detect anything in this communication that would have given you a heads up that this was coming, so you could have timed the market a little bit better?
Well, that's the whole point of this episode. It was quite interesting. They've taken, hundreds of thousands of emails that were exchanged, many of them completely innocuous, and they were trying to see if they could detect patterns that would be more indicative of more nefarious behavior about to unfold. Mm-hmm. And they were able to find, when you look at a very broad corpus of information, it's all fragmented, you can't really extract value from it. But when you start to connect the dots using AI models to see how communication is insulated perhaps from others in the organization, you can start to detect patterns. And they've used that information to also extrapolate to detect terrorist activity and communications that are more indicative of more nefarious types of communications between individuals. So I thought that was quite interesting, how data can be used for different purposes. And of course, there were many examples of data I'm sure that the original authors, if you can call it that, would not want in the public, particularly quite personal emails and exchanges that perhaps were not meant for the public to see.
Yeah. Go ahead, Clint.
I thought you were going to say that it was like a tool that lawyers put into companies to be like, if once you start typing this email, it's like, pick up the phone, call them, do not write this email, it'll show up in court.
Oh my God, we need to invent that, right?
Exactly.
And because how many times do we hear, we don't let our engineers or inventors or scientists do X because we don't want them emailing legal with something that will become discoverable later on.
Yeah, like the prior art teaches this, or we definitely infringe this patent. And exactly.
Right,
Oh,
but this is how you can extrapolate from like some, particularly seemingly random corpus of information and apply it to very specific use cases. So that's kind of what has become quite interesting.
So we did talk about data during this program. The one thing we did talk about in the last segment a little bit about trade secrets. Didn't do enough, I don't think, about trade secrets. I think next year I want to do more about trade secrets, but because the real value is the data, and there's so much that can be learned by, like if we sat down and we read all of this stuff, by the time we're done, we wouldn't remember what we got, and our notes would get different. I mean, did any of you grow up in a world where you had to go in with doing discovery for cases where they brought cardboard box of documents
Yes.
and that's now the kids that are coming out of law school don't know anything about that, right? Because it's all electronic discovery and everything. But you would be in a dark room, no windows, and it was always dark. There was never enough light. I don't know why they could never have enough light in these rooms, right? And when you're sitting in those rooms, you're going through this and like you're all gung ho at first because this is probably your first legal job, and then you learn pretty quickly that I'm going to be here in this room looking through boring crap for the next 12 hours, day after day after day after day. And what you do in the first minute is very different than what you do in the last minute. And even your notes get different. If you're trying to say, like, is this relevant? How relevant is it? How important is it on a scale of 1 to 10? Well, by the time you're done, like, everything is a 0 relevant, or whatever. Or it's all 10, But these machines can go through this stuff, and every review is fresh, same review over and over, crunch the data very quickly. But then that produces all kinds of information, and if you as a company are not protecting that as a trade secret from the minute it is created, it's not valuable because it will get out. Data wants to get out. Yeah. So what do companies, what do you think they should be doing? Do you have best practices? Have you had occasion to talk to companies about this? Or Stephanie, maybe you could tell us a little bit about what you do in your company with the valuable data, how you not use it, but like how do you make sure it keeps its value?
So I think, my company is a little unique insofar as, we're operating a very specific domain. And of course, inputs that are being generated inputted into our system by clients is certainly very confidential. But of course, as Jason mentioned yesterday, it's very table stakes for any company operating in the IP space that you can't use that data to then retrain your model for various different reasons, unless there's a particular benefit to the client. So for us, it's all sort of publicly available data, and I think that's true in the IP industry. And as you get into very specific domains and niches, that is true. Certainly in others, there's obviously a broad spectrum in other disciplines and other domains, but in ours, has to be sort of public.
It has to, right, the data. But so I guess what I was going for maybe is not like that, because data is not data. I mean, your data is not everybody else's data, and the data you ingest is what you ingest to learn, so the system learns. But I think where the real value comes in is in those insights, like you were just talking about. Like here's a whole bunch of emails from a bunch of people that we know some of them are hiding the world's biggest catastrophe, corporate catastrophe. We know that, right? But they're communicating every day with people. So what are the insights that can be gleaned from that data? And then the insights become data themselves, right? So I'll give you a for instance so you know where I'm thinking about. There were a lot of people that did not want Myriad to move forward and appeal that case because they were afraid of what might happen if it got to the Supreme Court. And there was a district court decision, and it said that you can't patent genes, you isolated. We all know what the holding was. And so they were advised, and I know that they were advised this by many people, maybe not their lawyers, but there were people talking to them from all sides, right? Stop, don't appeal. This is one district court judge. In that particular district court judge, there were some questions about whether he was senile at the time. He was quite old, and nobody's going to follow this. Nobody's going to follow it. Don't appeal it. And they didn't listen, and they appealed it, and then they ultimately lost. And they were sure that regardless of what happened, they were going to be fine, because at its core, their invention was the detection of breast cancer. And they had been doing this as the only ones under their patent for 15 years. So they knew that if they lost the patent and somebody started doing it tomorrow, that whoever started was not going to be nearly as accurate as they were, because over 15 years they got much better at identifying the cancer, identifying false positives, identifying false negatives, and really fine-tuning. But that's all about the data behind the scenes. So I think in this AI world, there's two types of data. There's the data that you need to make your platform smart, for shorthand way of saying all the LLM stuff, or large language models, LLM that go into that. And then there's what comes out of that, that's the insights, that's really the nugget of gold potentially. So I don't, we didn't talk about this as much as we should have probably, and I don't know a lot of others are really talking about this as much as you should. And that's one of the problems with trade secrets, because they have to remain secret. A lot of people who know this area don't talk about it. They don't want to talk about it. Their clients won't let them talk about it. And the companies that have that real valuable data don't talk about it. But what should people be thinking about? Both lawyers and companies on this side.
Well, I think, if you're gonna go too much one way or the other, it would be towards protecting everything as a trade secret, as opposed to not protecting enough, because once the data's out there, it's out there, and if you're not the misappropriator, then you can't even be held liable for distributing the data yourself or using it yourself. So I like the way you typically put it with trade secrets, Gene, which is that you have to do something to protect it. So identify what it is and do something to protect it. Now, from a legal perspective, from our perspective, this goes back to first principles about understanding your client's business, understanding what their objectives are, and then carrying out a legal strategy from that point forward. And I think you're right. The inferences that you get from this sea of data are really where the value is, and they need to be kept secret.
Yeah. And you got to do something. I've successfully used that argument in the past, because it's so easy. Like with companies, they'll it's a trade secret. Okay, well, what did you do?
Right.
And they won't answer you. And I remember vividly arguing in front of a judge who seemed to be, I thought, was buying the other side's argument. I'm like, look, no, stop. If they can't point to at least one thing, then there's no way that what they did was reasonable. And I'm like, so far, I had asked them questions. Did you have a locked file cabinet? Did you keep this in a locked office? Did you? And it was like, no. What did you do? What did you do exactly? And I think that's becoming very much more important as a lot of folks are getting access to really important insights.
Yep.
Go ahead, Clint.
So with all of these off-the-shelf AI tools, I think companies that are using them at different stages, I think a lot of it, honestly, is refining their prompt engineering over the years. And like you said, if you're 15 years ahead of somebody or 5 years ahead of somebody on, refining prompt engineering, then that's something that's extremely valuable to your company, and you should, have procedures and agreements in place to keep it confidential. And one of the big parts of advising clients on software stuff for patenting is letting them know, putting more details in is going to increase our chances of getting a patent for you, but it's going to decrease your chances of protecting it as a trade secret. And also, if we're putting a lot of back-end details in, that we might not necessarily know if somebody else is infringing, then if the bulk of your patent application is based on that, then you have to weigh, the possibilities of, you losing trade secrets because of it. But of course, there's always considerations of, well, we're not ever going to enforce our patents. We want, them to encourage investment, and there's a lot of, contradictory issues at play that you just have to discuss with your client, understand their business, and make sure that they're going into, filing a patent application with open eyes about what's happening.
Yeah, just add a few thoughts to that, actually.
Sure.
I think it's also important to further understand your client's business and what they're doing with the model as well. So is it generative? we seem to always conflate any sort of AI-based system. Of course, it's generative AI. Not all sophisticated AI, LLM-based technology is generative. And so if there is a generative component to it, certainly prompts and how they evolve over time would become a trade secret. My business is primarily non-generative. So our secret sauce is really what we do with the data, how we tune the model, how we weight different aspects of the documents that we are using to train the model. So certainly understanding your client's business and what they are building and for what purpose, what the input is, what the output is, whether it's generative or not, or where it falls along the spectrum of AI is extremely important.
Yeah. Yeah, I mean, because AI is not ubiquitous. There's all different kinds of AI.
Yeah. Dare I say it's a balancing test between what to include in a patent and what to keep back as a trade secret. But it's not mutually exclusive. You can disclose enough to provide an enabling disclosure and not specify the data sets you're using and exactly what you're doing. I mean, there is a way to maintain both, to
and
pursue
when you
patent
said
protection.
balancing test, I was thinking it's more like a juggling contest is what it feels like at times, right? And the reason I say that is because, whenever you write, well, what should this startup do? Okay, well, if the startup did everything that they're supposed to do, they would go bankrupt like in the first quarter.
Yeah.
So there's a lot of triaging that has to go on, and you're constantly trying to, catch the wind over here to blow the sails, and you'll go, maybe I want to go that way, but if I go that way, I can go that way far enough without any real energy before I make the turn. And, that's sort of the kind of 3D game of chess that startups play, is because they can't do it all. And this just adds an extra layer of complexity because you can't, because as I was thinking, is like, well, what does this do for patent strategy, or should companies be all in trade secrets? And then the reality of that is always, well, yes, but if you lose it, it's gone, and the company is worthless if you didn't have other stuff going as well. So it's delicate, and a lot of the decisions that the startup companies I think need to be making, and maybe even more so right now in the AI world, is with an eye towards what is going to attract the angel, what is going to attract the VC, and what might allow us to someday go public, because everybody's putting AI at their end of their name. Literally, now with the domain name .ai available, everybody's putting AI at the end of their name. And it feels like in some respects during the .com bubble, and I don't think this is that, but if you put E or I anywhere in your name, in your domain name, that raised your valuation, because there was. So I think there's some of that's going on, but I think there's a lot more there with this, and maybe it is a bubble, but I don't sense it's going to burst. I sense, to the extent that it's a bubble, what is going to happen is you're going to see a lot of these concentric bubbles merge and consume each other. I don't think this is a .com, like epets.com, where the bubble bursts and there's nothing there. I think we're going to start to see a bunch of companies join forces and merge. Would you agree, disagree?
Yeah.
Sorry, go ahead. Yeah, no, I was just going to comment. The only thing that could really have a very profound impact on the direction of this bubble, or whether it is or isn't a bubble, is where the copyright issues land. That's the biggest question mark, I think.
Yeah, there's a lot of scary uncertainty there.
Exactly.
I mean, I think I can predict with great accuracy how it's going to play out. It has to be infringement. It can't be fair use. And the reason I'm so confident in that is because the alternative ruling would make content creation a bubble. And the content creation is what we've been trying to protect in various ways. And in the U.S., it's in our Constitution. And countries going out back to the patronage system in Europe for hundreds and hundreds of years ago, all were about trying to result in more content being created, more art. And if this goes the wrong way, that content creation by a human will go away.
Well, Gene, I admire your optimism, but I do not have that level of faith in our institutions. I mean, look, I just said it earlier today about how Justice Thomas and Alice said we don't want this swallowing all of patent law, talking about patent eligibility, and that's what's it's what's happened. And if you look at pretty much any Supreme Court decision that comes to that relates to IP, the court is unanimous. They're unanimously wrong, but they're unanimous. There is no ideological divide, and it's always against the IP holder, right? And so even if they, like the Oracle copyright decision, I'm sure there was language in there that was meant to, cabin the holding, and it didn't. And so I just don't think these justices...
No, I have every confidence that the judges can get this wrong, and that is a possible outcome. What I think is that ultimately, if they get it wrong, from my content creator perspective, if they get it wrong, then Congress is going to step in, because they have to, because the forces, you'll have Disney, and what do we know about copyrights in Disney? Whatever Disney has historically wanted, Disney has historically gotten. And on top of that, you have all the movies and movie studios, you have all the recording artists, and then you have, for the first time ever, really joining this real coalition, as far as I can understand, is all of the major newspapers. You have the New York Times is a major plaintiff. You have the Getty Images. All of these people have got their own political power, their own sphere of influence, and I just think, so don't get me wrong, I think there's a real chance the courts get it wrong, but I think it will have to rectify itself pretty quickly if they do, because otherwise it changes everything, right?
Well,
like if you can watch, like live sports exists because of copyrights, right? They can make money on that because of copyrights, because when you're streaming it or broadcasting it, if you're recording it at the same time, you own the copyright in the event. That could all go away if all that stuff can be ingested instantly into an AI, and that's available right away. But you open all this copyright stuff up and say, oh, it's just fair use, then my goodness.
But again, not to disagree with the Oracle, but I don't think
contrarian.
I'll strike you down.
But I also don't think putting our faith in Congress is an adequate. It's not very heartening, right? And a lot of the entities you just named, Disney, the New York Times, they've become political in our modern discourse anyway. And so you're always going to have one side or the other who's going to say, well, screw these guys, I don't care about them. And then you have to consider the fact that IP in general is just very low on the totem pole when it comes to congressional priorities. I mean, they're doing, right now, taxes and all kinds of other stuff, immigration, things that are much more hot button issues, right? And then they're going off on impeachments and things like that. And I just don't have that much. I think that the myriad approach is just shut up and don't touch it. Don't say anything. Let it go. Right? I mean, I just don't have faith in our courts or Congress at this point.
Yeah.
Well, so I think you're correct that Congress doesn't care about patent law, but I think copyrights and trademarks are, more easily definable to the average person, and I do think there is interest, and I do think you could get momentum. I mean, you could get the New York Times and Fox News to be, on the same side of something. That would be crazy.
That's what I was thinking, because the whole world's become political, right? I mean, you can't almost avoid any political conversations anymore. And if one side wants to do something, the other side, even if they have historically agreed with that, now they have to disagree with it because that's the system we live in, right? Brought to us by 24/7 cable news, I think, right? Divisive.
Yeah.
But what I do think about this, and why I do have some confidence that it will eventually settle out right, maybe after a bumpy ride, is because of the political nature of, so it's like New York Times is clearly on one side, Fox News is clearly on the other side. And this is an issue that would affect both of them. So the people in Congress that like Fox and are on Fox and watch Fox, they're going to have the Fox people in their ear, and the people on the other side of the aisle who read the New York Times and like CNN and MSNBC, they're going to have all those people in their ear. And, most of us like going to a movie every once in a while, right? So the movie houses, I just think the coalition is going to be gigantic. At least I hope. Maybe I'm naive, and could be completely wrong. Renee's not here. She didn't hear me say that, did she? No.
No.
So,
But there's always going to be a lobby on the other side, right? Then you're going to have the AI lobby on the other side. You're going to have Elon Musk, who says, we should kill all of IP or whatever that tweet was, and so that's why I don't put that much faith in Congress, because there's rarely, if ever, any sort of agreement. They're all in everybody's hip pockets. Mm-hmm. They've got competing interests that they're listening to, which is why all legislation they come out with is lukewarm at best.
Yeah. Well, Elon is right that IP is for the weak. I'm not sure he got why he's right, though.
Yeah.
He wants to, I think, say it's for the weak, so we don't need it. We want, no. IP is for the weak because the big anymore just run roughshod over everybody. And that's one of the reasons why, if we want innovation to increase in the U.S., we have to create a climate that allows the innovators, the small people, small companies that are willing to take the risk to be incentivized and have rights and become tomorrow's big companies. Look at Silicon Valley. Google started with a couple guys in a dorm room. Most of those companies out there did. Apple started with 2 guys in a garage. Microsoft, 2 guys in a garage.
OpenAI.
I mean, all of these companies, HP, all of them. And now, today, it's hard to think that a 2-person startup in a dorm room or in your dad's garage will be in 10 or 20 years the next Google or the next Apple. And that is a huge problem. We don't have time to solve that problem, but we're going to come back and talk about that because that is a big issue.
Yeah. Well, I mean, look, we represent a lot of startups, and that's where all of the really high-risk innovation is happening. Not with the big companies that are doing safe plays.
Right.
And you're just going to completely discourage that.
Yeah, absolutely.
Yeah.
Well, thank you all. That was a great conversation. I really appreciate it, and I appreciate you also agreeing to help me out with content and programming, and I look forward to having you back on this stage and other stages that we bring to the audience in the future. So thank you.
Yeah.
Thanks, Jay.
Thank you.
Yep, a lot of fun. Thanks.